Very nice to see you all. Very nice to see you on Sunday session. You joined in that Sunday. On that Sunday, that session. If you wish to attend that type of session, you will be pay around 500 to 1,000 rupees individually. But with our social concern, he came forward and he delivered a talk and given high motivation to you on that day. In the society, the type of people are there.
సురేష్ సార్ మీకు హోస్ట్ ఇచ్చేయమంటారా?
Thing is, sir, I cannot see the screen also
ఓకే
simultaneously.
నో ప్రాబ్లం. గంగిశెట్టి సార్
I
మీకు
need to wear these specs to see the screen.
Sir,
So if
Okay,
someone
okay.
can help me, I will be very much indebted to you all.
ఓకే నో ప్రాబ్లం సార్. మీకు పీపీటీ ఎట్లా లేదు కాబట్టి
Yeah.
సార్ విల్ టేక్ కేర్.
Yeah,
నేను
please.
PPT లేదు కాబట్టి ఇష్యూనే లేదు కదా సార్.
True, sir.
హలో నరేష్ సార్. Naresh sir. Naresh sir. You may be attempting a phone call.
Yeah.
That may be happened.
Yeah, students, those who are listening online now, please forgive me. My eyesight doesn't permit me to see the PowerPoint slides. So generally, I don't depend on PPTs.
సార్
But
ఓకే
I
నో
will
ప్రాబ్లం.
prepare and share it with you. It's my promise to you. All
ఓకే
the
సార్.
bullet
ఓకే థ్యాంక్ యూ.
points that will suffice to meet your PG set exam, I will definitely prepare and post it in the WhatsApp group, right?
ఓకే సార్. ఓకే.
So with that lacuna in the session, I am ready to start with the permission of
Okay, sir.
our host, Naresh sir.
ఓకే సార్. సో very good evening students. Warm welcome to today's session. So once again warm welcome to Suresh sir.
Thank you,
So
sir.
assistant professor of commerce, senior assistant professor. So GDC Ibrahimpatnam, Government Degree College Ibrahimpatnam, Hyderabad. So warm welcome to another resource person of business law, Dr. Suleiman sir, and Dr. Gangishetty Srinivas sir, resource person and so co-coordinator of the program. So warm welcome sir. So I am requesting Dr. Gangishetty Srinivas sir, please introduce the today resource person. Thank you sir.
Sir, very good evening all. Special very good evening Suresh sir.
Good evening, sir.
Warm welcome to the virtual dais. And what is the intensity of the course? I would like to mention first. Now also 56 students joined. It shows that the concern of the students. We rescheduled time, but we did not lose a single person in the virtual dais. That's why this is a very useful program for the students of Telangana state of different colleges. You people, N.Suresh sir is working at Government Degree College, Ibrahimpatnam, and he is the noblest person and he is very human, best human, and he is rendering services to different colleges, and he is the key person for all the faculty who are involving in university activities. He is also resource person for so many seminars and key resource person for national seminars and state level seminars and international seminars. And he has been publishing so many articles. He is repeated in repeated journals, national and international. Sir, thank you for your acceptance, for your kind service. We are hearty welcome to the virtual dais. This virtual dais is yours. Students benefit more with like you people. Thank you once again. Warm welcome to this dais, and virtual dais is yours. Thank you so much, sir.
Thank you, Dr. Gangishetty Srinivas sir, for the heavyweight introduction you endorsed for me, though I don't deserve that much. As I told you earlier, my dear students, that I cannot see the PPTs, so it may be a bit boring for you. So please bear with me. So I'm sure that you read business law somewhere in second semester of your BCom and you're all done with your final year, right? So it's obvious that you forgot the basics of Contract Act, Companies Act, IPRs, Sale of Goods Act, and Consumer Protection Act. So what today and tomorrow I will do is I will scroll you through the Contract Act, probably the Sale of Goods Act also. Then the rest of the things will be covered by my best friend Dr. Suleiman sir from day after tomorrow onwards. So anyway, it's a paid version of Zoom, so time is not a constraint for us. So let us start. So friends, you're conversant with the fact that lion's share of business laws is covered by Indian Contract Act. So it's obvious that many questions from Contract Act can be asked in your PG set examination. So let us focus much on the tenets of Contract Act. Right. If you recall what you read in your second semester, Indian Contract Act 1872. It is enacted in the year 1872. So it actually consists of two parts. Part 1 from section 2 to section 75 and part 2 from section 124 to 238, right? So what happened to the rest of the sections from section 76 to 123? They are separated from Indian Contract Act in the year 1930 and made it to separate law called Sale of Goods Act 1930. The reason is obvious because the transactions pertaining to sale and purchase of goods would be very enormous comparing to the transactions on contract, like purchasing a house, purchasing a vehicle, purchasing other property, so on and so forth, right? So keeping this enormity of the transactions in view, back then in 1930 our colonial government has separated from section 76 of Indian Contract Act to 123 into Sale of Goods Act. So we have part 1 from section 2 to 75, part 2 from section 124 to 238. So what happened to section 1 then? Actually, section 1 has got no validity with effect from 2023. Why? Because section 1 says this act applies to whole of India except to the state of Jammu and Kashmir. But you are well aware that Government of India has done away Article 370. That means every act passed in Indian Parliament is duly and equally applicable to Jammu and Kashmir either. Therefore, the phrase which reads that this Contract Act does not apply to state of Jammu and Kashmir has got no validity anymore. So forget about section 1. Section 2 deals with definitions. What is offer, what is acceptance, what is agreement, what is contract, so on and so
Buyer,
forth.
seller,
Yeah?
even
Srivani,
buyer,
tell me.
seller, consideration, all that are included, no sir.
Yes, Amma. Yes, beta. Seller and buyer are not defined in Contract Act. Consideration is defined in Section 2, subsection D. We will discuss them. We will discuss them one by one. Wherever it is appropriate, wherever it is required, we'll come across the sections. Right? Okay. So with this basic anatomy of Contract Act, let us dive into what is contract and what are the kinds of contracts we do come across in our day-to-day transactions of business. So if anyone asks you a question, what is contract? You should corroborate your answer with section, appropriate section. So in which section contract is defined? It is defined in section 2, subsection H of Indian Contract Act. It is nothing but an agreement enforceable by law. Contract is an agreement enforceable by law. So contract has got two terms here. One is an agreement, another one is enforceability by law. I mean, mere agreement is not a contract. Contract is that agreement which is enforceable by law. That means which is recognized in the eyes of law. If you and I form a simple agreement without adding any legal tenets to it, it is a mere agreement. It is void in nature. So, if you fulfill all the essential elements cited in this contract act, only then agreement becomes a contract. We will see what those essential elements now itself. But the question is, what is an agreement? Any idea? You can unmute and answer me. What is an agreement and which section it is defined?
Agreement is a
Hmm.
Offer and
consideration between
acceptance. Offer and acceptance, sir.
Wonderful, wonderful. I am very happy you are actively listening to me. Well, according to section 2, subsection E of Indian Contract Act, every promise and every set of promises forming consideration to each other is called an agreement. That means I make a promise in reciprocation of which you also make a promise. And it is having consideration. Consideration means benefit to each other. It is called an agreement. I make a promise that I will sell my house to you. You make a promise that you will pay amount for it. So amount is there, house is there, that is benefit is there for both the parties. It's an agreement. So definition is a very clear, very vivid. According to section 2, subsection E, every promise and every set of promises forming consideration to each other is called an agreement. If that agreement obtains legal validity, it is called a contract. Now the question
offer and
is,
acceptance is, sir. Then
yeah, I'm coming to that better. So when the question is, when does agreement gets legal validity? I mean, when an offer, I mean, agreement is enforceable by law. Your points will come now: offer, acceptance, everything. All right. So there are 10 essential elements which every agreement need to fulfill so that we can consider an agreement as contract. If any of these essential elements are absent in the agreement, it cannot become a contract. So what are those 10 essential elements? We will see now. Number 1, there must be minimum of two parties, namely offerer and offeree. Who is an offerer? A person who initiates the process of contract. A person whose brainchild is the subject matter of contract is called an offerer. And to whom you are making offer is called an offeree, right? Once agreement is established between offerer and offeree, these two persons shall become promiser and promisee respectively. In the initial stage, offerer and offeree will be considered, but they will enter into the shoes of promiser and promisee once agreement turns into a contract. Now, at this juncture, you may ask me a question, sir, can there be a single party and sign an agreement? Yes, it is possible. What do you call a single party agreement? This question may come in your PG set exam tomorrow. A single person signing an agreement is called a will. In Telugu, what you call it as? Vilunama. Suppose father is dying.
Veelunam.
Yeah. So suppose father is on the verge of death. Father calls a lawyer and says, Lawyer Ji, please write entire property in the name of my daughter and make it a will. నా కూతురు పేరుతో రాయండి వీలునామా. So single person signing an agreement, that is called a will. But will cannot be a contract, my dears. Contract means there must be two parties. Who are those? Offerer and offeree. Clear? They are also called promiser and promisee respectively once they enter into contract. Once agreement turns into contract. That is the first essential element you need to remember. Second, there must be lawful offer and lawful acceptance. What do you mean by lawful offer? As Srivani was asking, sir, lawful offer is there? No. Offer is nothing but proposal. For a layman, offer is a proposal to do something. But we are law students. Our way of understanding offer should be different. What is the definition? How does it goes? Section 2, subsection A of Indian Contract Act defines that when one person signifies to another his willingness to do or to abstain from doing anything with a view to obtaining the assent of such other is said to have made an offer. That means I'm a person, I want to make offer to you to do or to abstain from doing. Why I will make offer? To obtain your assent. Assent means acceptance. To obtain your acceptance, I will make offer. You may ask a question, sir. To do a particular work, you can make offer. But to abstain from doing, abstain means from stopping
Stop.
from doing something. Should you make an offer? Sometimes so. I'll give an example. Suppose you and I are submitting tenders for a liquor shop, right? So both are sound parties, both will rig the prices of the tender. So we may come to an agreement. You don't submit your tenders in my area. I won't submit tenders in your area. So what we are doing, we are making offer to stop him from doing a particular act, to stop him from submitting tenders in an area. So it is also an offer. So offer can be made to do a particular work or to stop from doing a particular work. Why we make offer? To get the acceptance or assent of the other. Who is that other? Offeree. Right? That is the definition for the word offer. When one person signifies to another his willingness to do or to abstain from doing anything with a view to obtaining the assent of such other is said to have made an offer. Clear, my dears? And it must be lawful. You should not make any illegal offers or invalid offers. So, what is illegal offer and what is invalid offer? We will see in our next topic in 10 minutes down now. Next, there should be lawful acceptance. What is this lawful acceptance? See, offer is called proposal technically. Acceptance is called promise. Right? Acceptance is defined in section 2, subsection B. That is, the person to whom offer is made signifies his assent thereto. The offer is said to be accepted and becomes a promise. That is the definition of the word acceptance. Right? Section 2, subsection B defines it. Of course, at this juncture, you need not to mug up the definitions because your purpose of attending this session is to get the basic tenets and attempt multiple choice questions, MCQs in your PG set examination. So don't bother about definition part, just understand the gist of it. All right. So there must be two parties minimum, offerer and offeree. There must be lawful offer and lawful acceptance. Next, of course, there must be lawful consideration. What do you mean by consideration? Quid pro quo, something in return. That is benefit to each other. When both you and I are entering into contract without any benefit means we are not having any consideration. It is invalid in the eyes of law. Section 25 very clearly says no consideration, no contract. Clear? So this question may come in exam tomorrow. Which section of Indian Contract Act states that no consideration, no contract? Your immediate answer should be section 25. Without consideration, contract is invalid. It's a void contract. It's a void agreement. Clear? So consideration, of course, defined in section 2, subsection D. D for Delhi. What is the definition given? I already told you, don't bother about definition, but I will tell you now because as a teacher, it's my duty. So, when at the desire of the promiser, promisee, or any other person has done or abstained from doing, does or abstain from doing, or promises to do or to abstain from doing something, such act, abstinence, or forbearance forms consideration to such contract. Clear? So, how to decode this definition we will see in third topic. Simply you remember the juncture, consideration is the benefit derived by party from entering into contract or by executing the contract. So that benefit must be lawful. It should not be invalid or illegal. That is very, very important. Next, parties must be competent to contract. The parties, that is offerer and offeree, must be competent. They should have legal capacity to do contract. What is the difference between competency and skill? Can anyone unmute and answer me? The basic difference between competency and skill. Miss Ba is answering, I suppose. Tell me, Betty. No? All right. So simple. Competency is legal eligibility. Skill is only knowledge. Let us understand this way. A compounder working in hospital for decades and decades together know how to perform minor surgeries, know which medicine works for which disease. But is he legally eligible to give the medicine or to perform surgery? No, only qualified doctor is eligible. So doctor is competent. This compounder is only skilled. Understand? So competency is legal eligibility, skill is knowledge. So come back to our contracts. In order to become a party to contract or agreement, mere skill is not sufficient. Sir, I have a skill to do the work for you. Not sufficient. You must be legally competent, legally eligible to do the contract. Now the question comes, who are legally eligible to form the contracts? Number one, you must be a major by age. Who is a major? A boy or girl. Matrimonial age of majority is different, my dears. For the purpose of contract, no gender difference, no gender discrimination. Any person who completes the age of 18 years is a major. You must be a major to do the contracts or to form any agreements, right? Next, you must be of sound mind. That means your mental status should help you to exercise discretion on the subject matter to which you are going to become a party. So, who is a sound mind? Should not be lunatic at the time of forming the agreement. Lunatic means suffering with temporary mental disorder. At the time of entering into agreement, if you are suffering with mental disorder, that agreement is invalid if you sign by you. So once you obtain the mental fitness certificate, only then you can enter into agreement. Simply, lunacy is a temporary mental disorder during which you cannot enter into agreement. Second, you must not be an idiot. Idiot means it's not a scolding, my dears. Idiocy is permanent mental disability. That is the actual dictionary meaning. So, if any girl says you idiot, don't feel bad. She is simply saying are a permanent mental oda. Okay. So idiocy means permanent mental disorder. A person suffering with idiocy can never enter into a contract or agreement during his lifetime. But lunatic can enter when? If you prove the mental fitness. Clear? Third, under drunken conditions. That means if you are drunk at the time of signing the agreement, tomorrow you prove in the court along with the evidences, blood samples, so on and so forth. Sir, I was drunk. I was subjected to narcotic consumption at the time of signing agreement. Please forgive me. This agreement should be invalid because I was of unsound mind. If court is of the opinion, then agreement can be cancelled. If court believes in your evidences, agreement can be cancelled. So by all means, I want to say that your mental status must be sound enough to understand the subject of the agreement to which you are going to become a party. So in deciding the sound mindedness of a person, you should check lunacy, idiocy, and intoxication condition, sometimes insaneness also. So you should be of sound mind. You should be a major by age. Third, you should not be a foreign ambassador. Who is a foreign ambassador? A person representing country abroad. Suppose Indian High Commission is working as foreign ambassador in a country like America or UK. So his actions will represent entire country abroad. He got diplomatic immunity. That means the country where he is acting will not be arrested under any circumstances. He must be deported back to home country if anything is proven wrong from his side, but you cannot arrest him. So such impunity is given, and if he is allowed to enter into agreements, is doing some mischievous thing and brought to court, it's an insult to entire country. Therefore, our law clearly says foreign ambassadors are not entitled to form any contracts where they are discharging their duties in the capacity of foreign ambassadors. I will give a small example. I will deviate from the topic a bit, though it is not important for your PG set, because I thought it's important to you to understand. You all know about President K.R. Narayanan, right? Our former President of India, great intellectual. So, when he was discharging his responsibilities as a foreign ambassador in Tibet, he fell in love with a beautiful lady there. He married her, changed her name to Usha Narayan. And Indian Parliament, especially the opposition parties, outsloganed against him. So in those days, marriage was also a type of social contract. So he is working as a foreign ambassador abroad. He married someone there. How can he act impartially? Call him back. Then Prime Minister was Nehru at that time. He made amendment to government. I mean our Contract Act. He said the amendment says foreign ambassadors are entitled to form social agreements and social contracts like marriages, but they are not entitled to form commercial agreements or commercial contracts, which really matters for our business law. Clear? So, foreign ambassadors are not entitled to form business agreements, but they can do social contracts. If that amendment was not made back then in 50s, Nehru would have lost a great intellectual personality like K.R. Narayanan, isn't it? We'll come back. Now, so you know that you should be major to form a contract. You should be of sound mind to form a contract. You should not be a foreign ambassador. Next, you should not be an insolvent. Who is an insolvent? Diwala Koru, isn't it? A person whose total liabilities are more than total assets. And it is proved on the ground of law that he can never repay his excess liabilities. Then court will take away his assets and distribute them to the creditors and declare him as insolvent, Diwala Koru. He cannot enter into valid contract until he obtains solvency certificate. That means the rest of the liabilities he must clear over a period of time and obtain solvency certificate. My dears, believe me, so far in Indian history, once a guy is proved to be insolvent, he never tried to obtain solvency certificate. So once you are insolvent, you cannot enter into valid contract. Similarly, you should not be a convict. Who is a convict? See, difference is there between convict and accused. Accused may be in the jail, but he is not convict. He can enter into contract. I mean, every prisoner who is in jail is not a convict, right? So in Telugu, the difference Nerastudu Muddai. So convict is Nerastudu, on whom the guilty is proved. So punishment is imposed. So he cannot enter into contracts or agreements until the completion of his punishment. Whereas accused, Muddai, for simple reason that is a powerful man, he will tamper with the evidences. Court is not granting you bail, but you can enter into contract though you are in jail. Jagan sat in jail for 16 months, but his business ran. Sakshi paper, Bharti Cements, everything. Why? Because he was only accused, kept in jail as a prisoner. So he's entitled to form agreement or contract. Once you are a convict, guilty is proved, you cannot enter into contract, my dears. Clear? So any other person like alien enemy means person of that country with which we have officially declared a war. If India and Pakistan declares a war officially, and both of us will become allied enemies. So agreements cannot be signed between the citizens of Pakistan and India during the war because we are called allied enemies. Clear, my dears? So in order to decide the capacity of parties to sign agreement, you must see he must be a major by age, he must be of sound mind, he must not be a foreign ambassador, barring social agreements. You must not be an insolvent, must not be a convict, must not be an aligned enemy. That's the fourth point, my dears. Clear? One, there must be two parties, offerer and offeree. There must be lawful offer and acceptance. There must be lawful consideration, and capacity of the parties must be legally competent to form the contract, namely majority, sound mindedness, so on and so forth. Now, fifth essential elements of an agreement that turns agreement into contract is free consent. Suppose someone is putting a revolver at your point blank range and asking you to sign an agreement. Is it a valid agreement?
No, sir.
No, it is not. Because the consent which you gave there is not a free consent, right? So, if it is not a free consent, it is not a valid contract. It is only an agreement. It can be torn on the grounds of law. So, it must be free consent. Sixth, there must be consensus ad idem. Consensus ad idem means both offerer and offeree must understand the subject matter in same manner and in same sense. That is called consensus ad idem. I will give simple example. Kindly forgive me if it is not a dignified example, but it will make your understanding easy. Suppose one boy and girl want to elope from Hyderabad city, right? They switch off the cell phones with the fear that police will track them. Boy says to girl, come to St. Anne's College, 10 o'clock, I will be waiting for you tomorrow. That is understanding. Boy is waiting at Secunderabad St. Anne's College. Girl went to Mehdipatnam St. Anne's College. What happens? They cannot meet, right? Chalo. They went back to their respective houses. Next day, boy this time clearly says, please come to Secunderabad St. Anne's 10 o'clock sharp. Agreement is over. Chalo. Next day, girl came to Secunderabad St. Anne's at morning 10 o'clock and boy came Secunderabad St. Anne's at night 10 o'clock. What happens? Boy can never meet the girl and vice versa. So what happened in this case? There is no consensus ad idem. That means both the parties did not understand the subject of the agreement in same manner and in same sense. Therefore, there is no consensus ad idem, no agreement. So we can dare to state that the sixth essential element of an agreement is consensus ad idem. Both the parties must understand the subject in same manner and in same sense. Clear, my dears? Next, seventh, the subject matter of the agreement should not have been specifically declared void. Specifically declared void. From section 25 to section 30 of Indian Contract Act, we have defined few activities, few transactions as initially invalid agreements. They should not be there. For example, section 25, agreements without consideration, without benefit to parties is invalid from the beginning. That should not be your contract subject. Section 26, agreements in restraint of marital liberty. The liberty to marry cannot be restricted by any agreement, right? Section 27, agreement in restraint of trade liberty, except in the case of goodwill paid to outgoing partner, cannot be restricted. So, my liberty, my right to trade cannot be restricted by your agreement. That is invalid from the beginning. Section 28, agreements in restraint of legal proceedings. So, my right to proceed legally cannot be restricted by any agreement, except in the case of arbitration conciliation. We'll discuss that in the future. I mean, in the same class. Similarly, section 29, agreements without certainty, I mean, without clarity, are void. Similarly, betting agreements, wagering agreements. If India wins, I will pay you 10,000. If Pakistan wins, you pay me 10,000. It's called betting agreement, technically called a wagering agreement. So these six agreements are officially, that means formally, declared as void agreements in the ambit of Indian Contract Act, my dears. So the seventh point says your subject matter of the agreement should not be any one of these 6 points. It should not have been specifically declared void. Clear? Next, eighth one, agreements without certainty. That means agreements with uncertainty are void. Right? So certainty means clarity should be there. For example, one case law you might have come across in your second semester, Scammell versus Austin. In this case, what happened? One gentleman advertises in the paper that my house is available for rent or lease. Anyone is interested, please come and contact me. That was the advertisement given by Scammell. Another person, Austin, saw the advertisement in newspaper, approached the house owner and said, "Sir, your house is very old model house. If you renovate that according to the modern conditions, according to the modern style, I will take it for lease for 3 years." That was the agreement. So based on that agreement, house owner spent some money, renovated the house according to modern conditions or modern style, very flamboyantly decorated. And the other person came and saw it. Check, is this modern style? In our villages, even dogs will not stay in this house. Check, I don't want your house on lease basis. Then the house owner got angry. He went to court. Sir, he broke the agreement. We had an agreement that if I moderate the house, if I renovate the house, he will take it on lease basis. I spent the amount. Now he is not willing to take it. Please do me justice. The question is, can the house owner win the case? Anyone?
No,
No. Why?
written
Because,
document is not there.
yeah, tell me.
By written agreement is not there.
No. It is written. But the point is that what is modern style? What is modern condition? You did not define. What I feel is modern may be outdated to you. What you feel is modern may be outdated for me. Isn't it? So there is no certainty, there is no clarity in the agreement. Rather, the agreement should have been clearly drafted. Do false ceiling with so and so design. Give marble flooring with so and so design. Go for plaster of Paris painting with so and so color. So certainly you should have defined in the agreement. That is the reason why you see any agreements of property, it will be 5, 6, 7 pages because every term and condition will be vividly defined. Understand? So certainty should be there. Otherwise, it is invalid. That is the eighth point, my dear. Ninth point is there must be lawful object. It is not only the benefit, it's not only the consideration which must be lawful, but object, that is purpose, should also be lawful. Otherwise, agreement is invalid. It cannot become a contract. Sir, what is the difference between consideration and objective? Purpose and benefit. I will give an example. Suppose I will let my house to you on rental basis. I will get consideration of 20,000 rupees as a rent per month. It's my consideration, provided you must run a gambling house in that. You must run unlicensed casino in that. And means getting rent is a consideration, it is lawful. But running a gambling house or brothel house is a purpose, it is unlawful. So there automatically agreement between me and my tenant is invalid. Ultimately, I want to say that it is not the benefit alone, but the purpose of the contract must also be lawful. That means objective must also be lawful. Clear? And 10th one, the last one, any other legal formalities which the state stipulates from time to time. For example, a contract to buy a house or sell. Simply agreement is made. Is it sufficient? No. You must buy stamp papers from a registered vendor, go to registration office, obtain the registration process done by paying stamp duty and registration charges. So what these formalities are called? State stipulated formalities. They must also be duly fulfilled in order to convert an agreement into a contract. My dears, believe me, if any one of these is not fulfilled, it is only an agreement, but it cannot become a contract. So all the essential elements which I cited now, all the 10 elements must duly exist in an agreement in order to call it as a contract. So there's a clear difference between agreement and contract, which is the reason why agreement is separately defined in section 2 subsection E and contract is defined in section 2 subsection H. No doubt, as Shivani was telling, offer plus acceptance is equal to agreement, but offer plus acceptance plus legal enforceability is equal to contract. Understand? So this is agreement and essential elements of valid contract. Now let us see how many types of contracts we have. Can anyone unmute and answer me? How many types of contracts you remember, my dears? Anyone? I'll be very happy to listen from you. I'll get the confidence that my students are listening. Otherwise, I will assume that you simply logged in and forgot or kept your phones aside.
Valid contract,
Very wonderful.
voidable contract,
Wonderful.
void contract,
Wow, excellent. Are you
Voidable
seeing your phone and
contracts.
answering, my dear Rishikesh?
Legal contract,
Oh, excellent.
illegal,
Okay.
Illegal contract.
Told Amma. What
void,
else?
void contract,
Told?
Sir, voidable.
All right.
void contract.
Wonderful, wonderful. Okay. There enough. Mute yourself. So now and then, if I ask questions and you unmute and tell, I'll get the confidence that students are listening to me. Well, my dear students, I will classify contracts on 4 important bases. Okay, let us see one by one. Number 1, classification of contracts on the basis of validity. Validity means legality. Here we have, in this category, we have number 1, valid contract. What is valid contract? Lawful contract.
Enforceable by the law.
Very good. Srivani is correct. I mean, any agreement which fulfill all 10 essential elements and enforceable by law is a valid contract. Number 2, void contract. What is this void contract? Section 2, subsection J for Jeep, defines what is a void contract. A contract which ceases to be enforceable by law becomes a void contract. That means a contract which stops to be recognized by law. Ceases, C-E-A-S-E-S. Ceases means stops to be enforceable by law. It is called a void contract. That means in the beginning, contract is very much valid, but due to some unforeseen future circumstances, it loses validity at a future date. It is called void contract. My dears, don't get confusion between void agreement and void contract. They both are not same. There's difference between void agreement and void contract. What is the difference between void agreement and void contract? Can anyone answer me? No? Fine, I will tell you. Void agreement is defined in section 2 subsection G as an agreement which is not enforceable by law is called a void agreement. That means right from the moment of entering the agreement, it is invalid in the eyes of law. Right from the minute of entering into agreement, it is invalid. That's called void agreement. Technically, we can call void ab initio.
Void from the
Void- Yeah, very good. Void ab initio. This question may come in PG set tomorrow.
Yes,
Which
sir.
of the following is void ab initio? A. Void contract. B. Voidable contract. C. Void agreement. D. Illegal agreement. Your
Void
answer
ag-
must be void
void
agreement. So void agreement is void ab initio. That means from the
void
beginning it is invalid. But void contract in the beginning is valid, my dears. But at a future date, due to some unforeseen circumstances, it loses validity. That is the difference between void agreement and void contract. That's second one.
Give
Third
an
one, Amma,
state
yeah.
one example, sir.
What beta?
State one example. Give an
One,
example.
one example. Wonderful. I will give an example. Suppose if I sign an agreement with a minor to buy property from him, it is void contract or void agreement? It is
Void
void agreement because
agreement, sir.
minor is not competent to enter into contract. So right from the beginning, right from moment of signing the agreement itself, it is invalid in the eyes of law. Now, what is void contract? We will see. Our Srivani, after her BCom and MCom, became manager in Infosys. Happy beta? All
Sir?
right. Suppose that you have become a manager in Infosys Technologies, right? Happy?
Yes.
Assume. What is wrong in assuming, right? So your company sends you to America to book a premises in WTC, World Trade Center. So we want to open a branch office there. So dear manager, please go to New York, negotiate with WTC authorities, book a premises there. So on September 1st, our Srivani went and signed an agreement with WTC authorities. We want your your premises to run our branch office. We will occupy the premises on September 20th. Agreement is made. So rental deed is very much valid. So it's a valid contract on September 1st. But before you went to occupy the premises on September 11th, our Laden Mama has demolished WTC Twin Towers. That bogus fellow has hijacked flights and demolished WTC Towers on September 11th, right? You all know it. Kada 9/11 story. So, entire WTC towers are collapsed. They became debris and ashes. Now, on September 20, our Srivani goes to New York and demands, "Where is my premises?" Other fellow says, "Sorry, madam, premises was destroyed in terrorist attack." No, nothing doing. I have an agreement with you. Please honor that agreement. Otherwise, pay me compensation. Is your argument correct? Is your argument correct, Shivani? No,
Yes.
because the subject matter is destroyed
Yes, sir.
before the date of execution of contract. Therefore, the contract becomes void. I mean, on September 1st, when you signed agreement, it was valid. But on September 20, when you are supposed to occupy the premises and execute the contract, it becomes invalid. That is called a void contract. Clear? But void agreement means right from beginning it is invalid. Hope I am clear.
Yes,
Right?
sir.
Okay, that is void contract. Now, after valid contract and void contract, third we have voidable contract. What is this voidable contract? Section 2, subsection I of Indian Contract Act defines what is voidable contract. It is like this: a contract which is enforceable at the option of one or more of the parties thereto, but not at the option of other or others, is called a voidable contract. Nothing is understood, sir. Definitions are tricky, obviously. We need to decode that because for the PG set, no definitions are required. So simply remember, if any contract is such that one party in the contract is victimized, one party in the contract is aggrieved, or one party in the contract is deceived or cheated, such a victim will have a right either to go ahead with the contract by forgiving the other party or to cancel the contract. That is called voidable contract. Suppose someone is threatening you, someone is applying coercion on you and forced you to sign an agreement. Don't you think you are a victim there? Under such circumstances, you can go to court and say, Sir, I am victim here. Here is the evidence. So give me liberty either to cancel the contract or to abide by the contract. Right? So victim will have liberty to go ahead or to cancel. Such contract is called voidable contract. Next, of course, we have illegal contract. Fourth one. See, there's no formal definition for the word illegal contract, my dears, but we can understand from section 22 and 23 of Contract Act that if the subject matter of the contract or agreement is either partially or completely forbidden by law, it is an illegal agreement, right? It is not only invalid but a punishable offense. Clear? So this is the classification of contracts on the first category, first basis. Classification on the basis of validity. Valid contract, void contract, voidable contract, and illegal contract. Now, second category, second classification. Classification on the basis of formation, right? You have here expressed contracts, implied contracts, quasi contracts, and e-commerce contracts. What do you mean by expressed contracts? Section 9 subsection 2 says any contract which is formed either by words spoken or written is called expressed contract. Even words spoken will also form a contract provided those spoken words have supportive evidence. Don't be under impression that mere words spoken will not bind you in the court of law. If the spoken words got evidences in social media or another digital form, it is very much valid. Clear? Some change has come on the screen, sir. Am I audible, Amma, for everyone?
Yes, sir.
Yeah, okay. Some white screen is shown here. That's why I'm confused. Right. Now, number 2, implied contract. What do you mean by implied contract? Implied contract is that contract which is not formed by words spoken or by words written. Rather, through your implied actions, you are entering into contract. For example, boarding RTC bus and showing your bus pass. That is your action, right? That itself is prima facie sufficient to state that you are entering into contract with TSRTC or TGSRTC now. That means boarding the bus and showing the pass itself is an action that binds you and RTC into contract. No words spoken, no words written. Simply action of showing the pass by sitting in a bus is a implied contract. Third, quasi contract. Quasi contracts are those which are not formed between the parties by themselves, but courts will impose or law will impose contractual obligations between the parties. They are called quasi contracts. You and I won't form any contract, but law will impose contractual duties and rights between you and me. That is called a quasi contract. So quasi contract is also called constructive contracts. There are, of course, 5 different quasi contracts from section 68 to 72. I will skip that here because it's a very lengthy one. We'll skip from the, we'll deviate from the topic. Simply remember, from section 68 to 72 deals with quasi contracts, which are also known as constructive contracts. Section 68 says necessities supplied to minor. Amma? Venkata Lakshmi. Any doubt, Betty? All right. By mistake, you're unmuted, I suppose. Well, so minor is incompetent to form a contract. But if you supply any necessities to him, law will permit you, though there is no contract, to recover from his property. Section 68. Section 69, reimbursement of the payment made in good faith to save the property of others. So this type of examples are called quasi contracts, which will separately deal in other time, because for PGCET this much is sufficient. Quasi contracts are the obligations imposed by law but not formed between the parties by themselves. They're also called constructive contracts. That much you remember. And of course, next we have e-commerce contracts. So expressed contracts are words formed or spoken or written. Implied contracts are contracts formed through actions. Quasi contracts are obligations imposed by law. And e-commerce contracts, you did not express anything, but contracts are formed in digital format. Even an algorithm between two apps, mobile apps, binding a contract is also a type of, valid agreement. I didn't express anything in writing. You didn't express anything in writing. Your app and my app are meeting together to form an agreement. It's a digital agreement. Simply algorithms are mentioned. That is also a valid contract. They're called e-commerce contract. That is second classification, my dears. Understand? First one is on the basis of validity, where we have valid, void, voidable, and illegal contracts. Second classification is on the basis of formation, where we have expressed, implied, quasi contracts, and of course, e-commerce contracts. Third classification, on the basis of execution, that means on the basis of work done, we have executed contracts, executory contracts, unilateral contracts, and of course, bilateral contracts. What do you mean by executed contracts? It's a contract where both promisor and promisee have duly performed their obligation. It's past tense. Both the parties have discharged their obligations. It is called executed contract. Next, of course, we have executory contracts. Simply agreement is made, but performance is yet to be started. That is called executory contracts. Third, unilateral contract. Only one party has performed the obligation or discharged the duty, other party is yet to perform, is called unilateral contract. Bilateral contract, where both the parties are still performing the contract. See, don't get confused. Executory means both the parties have yet to start the performance. But bilateral means they have started the performance, but still they are doing work in progress for both the sides. It is called bilateral contract. That is third classification. And final classification, that is on the basis of British law, English law, right? Here we have two types of contracts, simple contracts and formal contracts. Simple contract is just like a business contract, buying a house, selling a property, so on and so forth. On the other hand, formal contracts are generally court contracts or government contracts. They are of two types. One, contract under record and contract under seal. Contract under record means judgments given by privy council or UK courts in civil disputes. As far as UK courts are concerned, or UK jurisprudence is concerned, civil dispute judgment is called a contract under record. Both the parties will sign that we will abide by this contract. But in India, even in civil disputes, we call the final settlement as judgment only, but not a contract. Only in UK it is called contract of record. Which one? A judgment delivered in civil disputes. Next, contracts under seal. If any contract is vetted by the official seal of the government, that is called a contract under seal. Not sealed cover contract, please. Don't get confused. These two are called formal contracts. So, with this, classification of contracts is also completed. Clear? Right. So far, we dealt with what is contract and essential elements and what are the types of contracts. Any doubts so far? You can unmute and ask me. It is 8 o'clock. We'll do one thing. I will ask you a few questions now. You must answer me. Right? Okay. So, in the view of PG set, I am asking you these questions. Anyone can unmute and answer me. All right. One question. Which section of Indian Contract Act defines voidable contract? Gayatri is answering. Tell me, Betty.
Section 2I, sir.
Wonderful, wonderful. Rishikesh Singh is answering, I think. Okay. If only victimized party, aggrieved party in the contract is allowed to execute it, what type of contract it is?
Voidable, sir.
Voidable contract. Shivani is correct. Very good. Quasi contracts are also known as dash. What is the other name? Amma, Kavya?
Contractive
Constructive
constructive contracts, sir. Constructive
Wonderful,
contracts.
wonderful. Constructive contracts. All right. So, contracts formed through actions is called dash.
Implied contract.
Implied contract. Navya is very good. Perfect. Right. Okay. So, next question. Which section of Indian Contract Act deals with free consent? Section 14. Right? And which section of Indian Contract Act defines offer or proposal? In the very beginning, I told you. Section 2?
Section 2A, sir.
Section 2,
Section 2,
subsection A.
subsection A.
Kavya is correct. Anusha is also correct. Wonderful. Very happy for you all. All right. So, contract under record. A is a practice in which jurisprudence? A, India. B, Spain. C, Latin America. D, UK.
Sir, repeat the question.
Contract under record is a practice in which jurisprudence? A, India. B, Latin America. C, Spain. D, UK.
India.
No.
Yes, sir.
It's UK. I told you, no? Classification under English law or British law. So British as UK, isn't it? So this type of questions will come in your PG set tomorrow. You should not get confused, my dears. All right. Okay. Now, can we go ahead with other topic?
Yes,
Can you
sir.
spare another half an hour to 40 minutes for me?
Yes, sir.
Wonderful. Right. Now, our next topic will see offer and acceptance. I told you what is offer already. Offer is defined in section 2, subsection A, right? When one person signifies to another his willingness to do or to abstain from doing anything with a view to obtaining the assent of such other is said to have made an offer to do a particular work or not to do a particular work. In order to know the intention of other person, you are making a proposal. It's called an offer, and the person making offer is called offerer. Section 2, subsection A. Offerer or proposal both mean same. Honestly speaking, there is no word called offer in 2A. It is technically written as proposal. Don't get confused. I am confusing you. I'm sorry for that. Right. How many types of offers are there? Any one of you remember, Nana? Vaguely. There are 5 types of offers. Number 1, general offer. Number 2, special offer. Number 3, cross offers. Number 4, counter offer. Number 5, tender. These are 5 types of offers. Let us discuss one by one. General offer. Offer made to public at large is called a general offer, to which anyone can give their acceptance. Have you heard about Carlyle versus Carbolic Smoke Ball Company case from your BCom second semester? No?
No, sir.
No. Okay. I'll tell you what this case, very interesting case. In this case, one company, Carbolic Smoke Ball Company, made advertisement in the paper. Anyone using our product will not be infected by influenza. Influenza is a type of disease, right? So use my product, you will not get the disease. If anyone, I repeat, they wrote the word, if anyone, that means public, general public at large, if anyone gets disease or influenza even after using our product, we will give compensation. That was the offer made in newspaper by company. One lady, her name is Carlyle, saw the advertisement, purchased it, and used the product. Despite using the product, she caught with influenza. Influenza means chalijuvaram, simply. So she went to company. Based on your advertisement, at the strength of your advertisement, I used your product, but I got disease. I mean, I got influenza. Give me compensation. Then company said, no, Tuch, did you come to us before using? Did you sign any agreement with us before using? So we will not give any compensation. That lady got angry. She went to court and she filed a suit against the company. She won the case. How did she win the case? Because the offer made by company is a general offer. Anyone using my product will be compensated if you get the influenza disease. So they made general offer. I gave my acceptance through my implied action. There is implied acceptance. So offer plus acceptance is equal to agreement. Consideration is there, legal enforceability is there. So it is valid. Court also agreed. Then asked the company to pay compensation to that lady. This is very, very important case law, my dears. Why it is important, you know? After this case took place some 100 years ago in UK. But after this case, globally, companies started writing beneath the offer small words, terms and conditions apply. But before this case, terms and conditions are applied. This caution was not there. So company was aggrieved there. Now my question is, Fair and Lovely 1 week challenge, Dove 1 week challenge, TV advertisement comes, no, use Fair and Lovely for 1 week. Color will be changed, otherwise money wapas. Using Fair and Lovely from my childhood, same skin, same color, no change. Can I claim compensation on the premise that it's a general offer? No, because Fair and Lovely company writes small words, terms and conditions apply. Okay, so this case, Carlyle versus Carbolic case, is the hallmark judgment based on which terms and conditions practice has come into picture. But in general, you remember that offer made to public at large is called a general offer, to which anyone can give acceptance. It's a valid offer. It's lawful very much. Second is special offer. That means specific offer. I make offer to Mr. A. If Mr. B is giving acceptance, can I enter into contact with Mr. B? No.
No, sir.
When offer is made to Mr. A should alone give acceptance to me. That is called special offer or specific offer. It is also valid. 99.9% of offers made to form contracts in day-to-day operations are special offers only. Specific person is the offeree to whom we make offer, right? General offers are obvious phenomena, but rarely we go to court on the premise of general offers. Now, third, cross offers. Okay, what is this cross offers? I'm using plural offers, not singular word. See, when two identical offers are exchanged between the parties in ignorance, they are called cross offers. I mean, both offerer and offeree are exchanging same subject matter in ignorance. There's no word called yes, it's acceptable to me. It's called cross offers. They are invalid. I'll give a simple example. I can see someone on the screen, T Kavya. Kavya, which is your hometown, Betty? Can you unmute and tell me?
Kamareddy, sir.
Kamareddy. Okay. Now, I am writing a letter to Kavya. Miss Kavya, will you sell your house at Kamareddy for 1 crore? I am writing a letter to her. I am making an offer. Will you sell your house at Kamareddy for 1 crore? So she don't know that offer because the letter is not yet received to her. She also wrote a letter to me without knowing my letter. Dear sir, will you buy my house at Kamareddy for 1 crore? That means she don't know that I wrote a letter. Meanwhile, she also wrote a letter. So what I am writing, will you sell your house for 1 crore? What she is writing, will you buy my house for 1 crore? Don't you think both the letters have same subject matter? None of us said yes, it is acceptable to us. So none of us gave acceptance. Only two same offers are exchanged between the parties in ignorance. They are called cross offers. They will not create any contract, my dears. It is invalid in the eyes of law. General offer is valid, special offer is valid, but cross offer is invalid. Clear? Now, counter offer. What is this count?
Bargain.
Amma?
Bargaining, sir.
Not bargaining. Of course, partially you are right. It's bargaining, but it's like this: putting condition.
Rejecting of original offer and
Pardon? Bit louder, Srivani.
rejecting of the original offer and sir.
Not rejecting exactly. Suppose I gave you acceptance by putting a condition. I'm giving you acceptance by putting a condition, or I am encountering one offer with other offer. It is called a counter offer. I will give an example better. You will understand it easily. Suppose my friend Naresh sir, I think is online. So Naresh sir made me an offer. Dear Suresh, will you buy my house at Karimnagar for 1 crore? That is the offer he is making. Will you buy my house at Karimnagar for 1 crore? I received the letter. Oh, ho. I gave a reply. Yes, sir. I will buy your house at Karimnagar for 1 crore, provided you will buy my chicken shop in Hyderabad for 20 lakhs. So what I am doing here? I am encountering his offer with other offer, or I am giving acceptance to him by putting condition. Mind it, acceptance must be unconditional. If I put a condition and give acceptance, it is called a counter offer. Understand? So if I simply say, yes, sir, I will buy your house for 1 crore, it's a valid acceptance. And the offer made by him is a general regular offer. But if I am putting a condition, I will buy your house provided you will buy my chicken shop. So I am putting a condition. So counter offer is either a conditional acceptance or encountering the original offer with other offer. Clear? Right. Now, it's invalid in the eyes of law. Fifth one, tender. Tender is also an offer, please. But it is an offer submitted in response to invitation to offer. That means the person who want to do the work, who want to initiate the contract, will not make any offer. He will make invitation. Those who want to bind me in the contract, please make your offers. If it is acceptable to me, I will give acceptance. I'll give a simple example. In your Kamareddy or Karimnagar, municipality want to construct a flyover or road bridge. What it will do? It will make invitation in the paper, tender invitation, tender afanamu. It comes in newspaper, no? So government want to construct a flyover or a bridge at so and so place with so and so specifications. So whoever is interested, please submit your offers. That means please submit your tenders. So Shrivani submitted, I will construct it for 1 crore. Rishikesh submits, I will do it for 90 lakhs. Kavya says, I will do it for 70 lakhs only. You are making offers. They're called tenders. Then I will give acceptance to Kavya or someone who is quoting 70 lakhs, the lowest one. So I am inviting you to make offer. Whichever is acceptable to me, I will give acceptance. So the offer you are making in response to my invitation is called tender. Clear? So
Yes, sir.
these are 5 types of offers, Nana. Among these 5 type of offers, please remember that cross offers and counter offers are invalid in the eyes of law. They are invalid because they will not form any acceptance or they will not create any contract. Tomorrow, if question comes in PG set, you must be in a position to answer. Which of the following is invalid offer? A. General offer. B. Special offer. C. Tender. D. Counter offer. Your answer must be
Counter offer.
counter offer. This type of questions will come. Oh, someone, Priyanka, also Ekashila Degree College also joined. Very happy. New students are coming on the screen. So this type of questions will come. Now, after understanding the definition of offer and types of offers, now let us see what are the essential elements of lawful offer. Suppose I make an offer to kill a person and give you 1 lakh rupees. Is it a valid offer?
No, sir.
No. Then what constitutes valid offer? When an offer is considered to be valid in the eyes of law, it must also fulfill certain essential elements. We will understand that now, right? So if these essential elements are duly fulfilled, offer is valid in the eyes of law. Number one, offer must be made with intent to abide by it. I made an offer. That means, are by masant or mastri, I want to construct a house. This is the plan. This is the rate I will propose. He said, yes, sir. Acceptable to me. Agreement is over. Mason said, sir, give me 5 days time. I will go to my village. I will hire labor and come. So he went to village. He hired labor. He procured the construction material and came to me. Ready for construction, sir. I said, Tuch. Just like that, I said, bye. I don't have any intention to construct now. Go. Will he keep quiet? No, he will drag me to court, isn't it? Because I must make offer to abide by it. Offer must be made to abide by it. Number one. Number two, offer must be made to obtain the assent of the other. Why we make offer? To obtain the acceptance of the other party. That is offeree. Clear? That is second essential element. Third, offer can be general or specific. I told you already. Even general offer made to public also is a valid. It can be specific also. Offer can be general or specific. It's valid. Next, offer must be communicated to offeree. To whoever person you want to make offer, that offer should be communicated to him. Then only he becomes a party to contract. A very, very famous case law is there. Gauri Dutt versus Lalman Shukla. Have you heard about this case, my dears? Anyone? Now, I will tell you without killing the time further. What happens in this case is there was one master. Master means a owner, employer, someone, house owner. His name was Gauri Dutt. He had one servant working at his house. His name is Lalman Shukla. Master servant. Fine. What happened one day? A small boy, a small family member, a 5-year-old boy, went missing from the home. Some nephew of the house owner. So everyone went on searching that boy. Obviously, Lalman is a servant. He will also search, no? So master said, hey, poor fellow, my nephew gone missing. Please go and search. So he took the instructions of the master and searching the nephew. Fortunately, the servant traced the missing boy, successfully brought him home. There ends the matter. But there was a paper advertisement that anyone traces my missing nephew will be rewarded with 10,000 rupees of cash. But this poor fellow, servant Lalman Shukla, is not aware of that case. He is not aware of that advertisement. Without knowing anything about the paper advertisement, he successfully brought the boy home and handed over. After cutting the scene, after 3 months or 4 months, Lalman came to know that there was an offer in the paper. Anyone traces the missing nephew will be rewarded with 10,000 rupees of cash. He went to master and asked, sir, I heard that you gave paper advertisement that anyone traces the missing nephew will be rewarded. It is me who brought the boy home. So give me compensation, sir. The master said, nothing doing. I will not give you. The servant went to court. Can the servant win the case? Anyone? You want me to ask the question in Telugu? It's very interesting. But the Lalman Shukla who went to court for compensation did not get it, did not win the case. Why? Because
Lapse of time.
the activity you performed was in the relationship of master and servant. Had you noticed, have you taken the cognizance of the advertisement before starting, then your master and servant relation would be subsumed into promisor and promisee relation. Then you can get the compensation. But in this case, what happened? You did not notice about the offer. Offer did not reach to you. Offer is not communicated to you. So whatever work you have done is in the capacity of master and servant. So you will not get any compensation. Poor servant lost the case. So ultimately, I wish to tell you from this case that offer must be communicated to offeree. Clear? That is third one. Next, offer can be conditional, but conditions must be communicated in the very beginning. Along with the offer, conditions must be communicated, please. Acceptance should not have any conditions, I'm telling you. Acceptance must be unconditional, but offer can be conditional. You have to communicate the conditions along with the offer. That is very, very required. There are so many cases, very, very interesting cases on this communication of conditions, but time doesn't permit me to go ahead with that. Now, next one. Offer cannot be implied from silence. Right? You should be made it explicit or implied. Similarly, mere price declaration is not an offer. Suppose you went to supermarket. There's a display of products. You took up one product and you went for billing counter. The billing desk fellow says, no, sir, it's not meant for sale. Then you argue, Arey, poor fellow, you displayed it. The price is also mentioned. It's an offer. So I took it. I want to buy it. I am giving you acceptance. Offer plus acceptance is equal to agreement. You are saying no. What is this? Are you teaching me law? Then your argument is wrong, my dears. See, mere price declaration is not an offer. Simply declaring price is not an offer. Very, very famous case law is there. Harvey versus Fassy. This case may be asked in your PGCET exam. Which of the following cases settles the law on mere price declaration is not an offer? The answer should be Harvey versus Fassy. What is that case? Anyone help me? Very famous case it is. Sir, we don't remember our 6th semester papers. How can you dare to ask us 2nd semester questions? Should not ask, right? I'll tell you what happened in this case. In this case, one fellow Harvey had a habit or hobby of collecting old articles or antique pieces. He came to know that one boy or one man called Fassy had a bumper hall pen, a very rare pen used by Queen or someone, we don't know. But that pen is very rare pen. Fassy has got that pen. So Harvey wanted to have it because it's a hobby to collect his old antique pieces. He made a letter. He wrote a telegram to Fassy. The telegram had 2 questions. Will you sell your bumper hall pen? Please quote the lowest price. Fassy saw the telegram and replied, lowest price is 850 pounds. Harvey, oh, 850 pounds is very much acceptable to me. Give it. Fassy said, Toch, I don't give. What is this buy? I made a telegram offer to you. You quoted the price 850 pounds. It's accepted. Offer plus acceptance is equal to agreement. Now I came all the way with my money. Now you are saying I won't give the pen. It's violation of agreement. I will file a case. Can the Harvey win case? No. Listen carefully. Listen carefully. In first telegram, you asked 2 questions. Will you sell? Second question, what is the lowest price? Fassy answered, Only second question, lowest price. But he did not answer the first question, whether he will sell or not. So only price declaration is not an offer. Clear? And finally, my dears, offer must be distinguished from invitation to offer. I told you, if I am making invitation, you submit offer. So invitation cannot be taken as offer. Invitation cannot be a legal offer. You should make offer. So these are the essential elements of lawful offer, right? Now, acceptance. We'll do one thing. We'll do with acceptance, then we'll stop. It's already 1.5 hour done. It's 8:30 almost. So acceptance we'll do. Then we'll go for any Q&A. If you have any doubts, we'll discuss. So acceptance means promise. Section 2B, Section 2 subsection B says, the person to whom offer is made signifies his assent thereto. The offer is said to be accepted and becomes a promise, right? So what are the essential conditions of a lawful acceptance? Number one, right? Acceptance must be unconditional. If you put conditions in acceptance, it is called
Suresh sir, sorry
Sir,
for
sir.
the interruption.
Please, sir.
సార్ అయితే యాక్చువల్లీ నేను 7 to 8:30 పెట్టిన అది ఆటోమేటిక్ గా పెరుగుతుంది కావచ్చు. ఓకే, పెరిగితే నో ప్రాబ్లం. ఎంతవరకు అయితే అంతవరకు చెప్పండి. ఒకవేళ 8:30 కట్ అయిపోతే we will continue tomorrow same time కదా సార్?
Same
7
o'clock, please.
రేపు ఏం చేస్తా అంటే 7 to 9 పెడతాను.
Wonderful,
ఎక్కువ
sir.
ఇప్పుడు కూడా ఆటోమేటిక్ ఎక్స్టెండ్ అవుతుంది కావచ్చు. మేబీ ఎంతకైనా ముందు కానీ ఫ్రీ కాషన్ గా చెప్తున్నాను.
Right,
So
sir. If it is not
student
extended, I will put in the WhatsApp group what has to be
Okay.
continued tomorrow.
ఓకే సార్. సో
Right.
స్టూడెంట్స్ టుమారో కూడా ఈ క్లాస్ సేమ్ 7 to సార్ ఆల్మోస్ట్ 8:39 వరకు ఉంటుంది.
Yeah.
ఇప్పుడు సార్ యాక్సెప్టెన్స్ వరకు కంటిన్యూ చేస్తాడు. ఒకవేళ ఇఫ్ కట్ అయిపోతే
Tomorrow.
టుమారో కంటిన్యూ చేస్తారు సార్. ఓకే సార్. ఓకే సార్, కంటిన్యూ ప్లీజ్.
Right, sir. Right, sir. Thank you for that caution note. So, my dears, acceptance must be unconditional. If you put a condition in the acceptance, it is called counter offer. I told you earlier, right? So acceptance must be unconditional. Or number two, acceptance must be communicated to offerer. I told you offer must be communicated to offeree, right? Now I am telling you acceptance must also be communicated to offerer. Clear? Third, acceptance must be given within specified time. If time is mentioned in the acceptance, it must be given within specific time period, right? Next, acceptance must be given in the mode prescribed. Suppose I'm an offerer, I'm asking you to give acceptance through telegram only, but you gave your acceptance through courier. Mode is changed, so it's not a valid acceptance. So if I prescribe a mode, you must give your acceptance only in the specified mode. Acceptance must be winnowed from free consent. No one should obtain acceptance from you on jabardasti basis. No forceful acceptance. It must be free and genuine. Clear? So free consent is quintessence of lawful acceptance. Similarly, acceptance cannot be implied from silence, but acceptance can be expressed or implied. You need not to express in words. Even through implied actions, acceptance can be communicated and bind the other party with contracts. Clear? So this is about acceptance. So far today, my dear friends, we discussed 4 important topics. I'm expecting at least 2 or 3 questions from this, because very, very important topics these are, right? So now I want to open it for discussion. Anyone having doubts with respect to essential elements of lawful contract, types of contract, there is classification of contracts, offer and acceptance, types of offer, you are open to ask me. If you don't ask me, I will ask you questions. It's 8:30 all 8:32, my dears. Okay, so it is extended automatically. Very good buy. I must also buy the paid version of Zoom. Any doubts so far? Those who are scrupulously listening to me? No
Students,
doubt?
please
Sir.
unmute yourself and answer.
Any doubt so far?
Sir, can you explain about basis of British law once again?
Based on
Basis
British law.
of British law.
Classification of contracts on the basis of British law, right?
Okay, sir.
Raju, thank you, Nana. Very good. See, the genesis of Indian Contract Act lies in British laws. For that matter, 70 to 80% of the legal literature, the Indian judicial literature we are following today, is developed by Britishers. Example, Contract Act 1872. 150 years back, British people made it. Even today, we are following the same. Partnership Act 1932 before independence. Even today we are following it. Sale of Goods Act 1930 before independence. Even today we are following it. Cooperative Societies Act 1911 before independence we are following it. Like that, AP Police Act, Indian Railways Act, Telecommunication Act. There are so many acts designed by Britishers which we are following even to this very day. So it is worth understanding how Britishers treat contracts, how many types of contracts Britishers do have. With that intention, I gave you the classification of contracts on the basis of British law. See, in British law, contracts are classified into two categories. One is simple contract, other one formal contract. Simple contract, Raju, is nothing but regular commercial contracts, regular business contracts, buying a house, selling a property, buying a vehicle. So simple, regular business transaction. It is called simple contract in British law. On the other hand, we have second category called formal contracts. Formal contracts are not between two individuals honestly. They are with the system, individual and system. System means it can be court, it can be government, like that. So formal contracts are of two types. One, contract under record and contract under seal. Let us see one by one. Contract under record. See, in the case of civil disputes, any judgment given by British courts is called contract under record. In India, civil dispute, whatever court verdict comes, is also called as judgment. But in British law, sir, I have a property dispute with other party. You give us the judgment. We both will abide by it. We both will sign that. We will abide by your judgment. That's called contract of record. It's a judgment honestly given in the case of civil disputes. So what is the difference between civil law and criminal law? Civil law functions on the edifice of dispute and settlement. On the other hand, criminal law functions on the premise of crime and punishment. Do you agree, Raju?
Yes,
right?
sir.
So in the case of criminal law, in British jurisdiction also, the final verdict of the court is called judgment. But only in the case of civil disputes like property disputes, business disputes, distribution disputes, the verdict of the court is called contract under a record. It's a type of formal contract. We have other type of formal contract either, that is contract under seal, SEAL seal. Seal means not a sealed cover. Seal means if any agreement or contract is vetted, that means is recognized with the official seal of the government, it is called contract under seal. That means any agreement with government of UK is a contract under seal because that agreement will be vetted by official stamp of the state. That is a kind of formal contract. Clear, Raju?
Okay, sir. Thank you, sir.
Okay, all right. So please do read these two questions. Tomorrow when you join, you please go through your topics like consideration, free consent, discharge of contract, remedies for discharge of contract. That will do the Contract Act. Then I will also throw some light on Sale of Goods Act and IPRs or even Consumer Protection Act. That will help. Up to 9 o'clock, it will be extended. So mentally prepare for 2 hours class tomorrow from 7 o'clock to 9 o'clock. Don't say sorry, it's boring. If those who will I'm boring, you can sign out. Rest can listen to me. So tomorrow I will do the rest of the part. Companies Act will be dealt by our other resource person, Dr. Suleiman sir. So see you tomorrow evening, sharp 7 o'clock, my dears, up to 9 o'clock. Right?
Okay, sir.
All right. Naresh sir,
Thank
I'm
you.
done for today. Hello, Naresh sir, are you there?
Naresh sir is there.
Yeah, Srinivas sir. Okay, we are done, sir. We are done for today. Shall we call it a day, sir?
Okay, sir. Okay. Before close, okay.
Yeah. We
Thank
will
you.
call.
Thank you so much, sir. Thank you
Thank
so
you,
much.
sir.
Tomorrow we
We'll
will.
call the curtains down today. We'll meet you tomorrow.
Yes, sir. Tomorrow we will meet
Right.
in the same platform, on the same
Right, sir.
platform.
Done,
Thank
sir.
you so much, sir. Thank you so
Thank you,
much. I
sir. Good
don't
night,
want to
sir.
mention more
Thank you.
because
Thank
of
you.
your continuing research person. Why should I
Thank you.
mention more? Right. Thank you.
Right, sir. I
Thank
will
you.
sign out now. Thank you, students. Good night, all of you. All right.
Suresh sir, thank you very much.
Thank you, sir. I am done for today. Tomorrow I will take 2 hour session, sir. I promise students. So give me 2 hours tomorrow, 7 to 9 o'clock.
Okay, sir. Thank you. Thank you
Right,
all
sir.
the students for
Right, sir.
patiently listening.
We'll call it a day. Good night, all of you. We'll sign out.
Thank you, sir.
Right, sir. Bye-bye. Where should I sign out? And I didn't give the desktop version so far in Zoom, so I'm not aware of it. Okay, it will automatically terminate once.